Okay, to have a look at the topic of developments in the law regarding consequential loss, we have Anthony Duper. Anthony, welcome.
Good afternoon, colleagues. Thank you for having me. Or good morning, is it still? Just. I work as a freelance lawyer. Basically, my clients are other lawyers. I contract myself out to other lawyers. Sometimes practitioners and firms I'll do drafting for, but mostly I target my services to the in-house market. So in-house legal departments that have a particular need for a project, or if someone's on maternity leave or whatever, I slot into their team, or I work as an external lawyer as well. So, focusing on the in-house market, I do a lot of work then. I do a lot of buying and selling. Work a lot sometimes with procurement departments, and you're either, often it's very dull work. You're the in-house lawyer, either selling something or to another company, or buying something from another company. And so, very important in that becomes exclusion clauses. And I've seen some quite dispirited, broken-hearted in-house lawyers who can't face, negotiating out exclusion clauses yet again. So it's something that plays on my mind a fair bit. And the classic exclusion or limitation of liability clause would be to put it on dollar value and say, well, we'll supply you this widget, this basket of widgets. Our liability is limited to $5 million or some dollar amount. And you also get, though, I'm telling you what you know already, but you also get then limitations of liability or exclusions where they'll exclude a concept. And it's the exclusion of the concept of consequential loss that's something I found becoming troubling. And it was a few years ago in one in-house job. I was working for a company that was selling some material that was a waste product. It was waste material. They weren't the normal process of selling this stuff. But for the present purposes, they were a supplier. They were negotiating with a customer. They were happy about the idea that if they were liable, their material was no good, that they'd have to come and collect it and take it away and replace it and so forth. But they said, what we're worried about is if this material gets used and all caught up in the customer's machines, we don't want to be liable for coming and cleaning it out of the machines. And we've negotiated an exclusion of consequential loss clause. They said to me, will that cover it? And so all my alarm bells were going off, obviously, and I, particularly as an external lawyer, could feel all the risk being pushed over to me now to make a call to say, well, you're doomed, really. You say, yes, it'll be fine, and then it comes up. And so I gave them the appropriate sort of advice, saying, well, you can't advise on something like this in the abstract. It's a 50-50 thing. You never know. But I did try to do some research on consequential loss at that time, and I tried to give them an appropriate nuance or sort of answer. And as you often get in these things, the ideal of contracting that we've heard of a meeting of minds, it just doesn't really happen that often in the big companies, and it's more, well, we'll just sign it and hope for the best. And we might think the clause means this, and they might think it means something different, but as long as we sign and do the business, that's the main thing. So they signed it anyway, did the deal and got on with it. I made sure my insurance was nicely unexposed in the transaction. So, and a few years later I was negotiating with a customer acting for a supplier again, and this was our usual material that we would sell in this company. It was our core business. And and we sought to exclude liability for consequential loss. And the other side said, no, we're not going to let you do that. You've heard the peerless decision, haven't you? I said, yes, of course. And they said, because of this decision, we're not allowed to let you exclude consequential loss anymore. And I said, okay, I'll go away and think about it. And I hung up the phone and I looked up the peerless decision. You've got to learn on your feet sometimes. So it doesn't all come like this. 10 hours a week isn't really 10 hours a year. So I looked it up, and what I got from it in a nutshell was that the definition of consequential loss is potentially expanded, such that now customers were understandably a bit more cagey about allowing exclusion of consequential loss. So we ended up negotiating an exclusion for not the term consequential loss, but a whole big list of loss of profit, loss of opportunity, loss of revenue, all this stuff. And in the end, I wondered whether that actually ended up being a bigger exclusion, because I was very fulsome in my list. And then later still, soon after that, I was able to turn, and I was a customer now, and I was negotiating as a customer. and a supplier came to us and said, well, you know, we want to, part of their clauses was we want to exclude liability for consequential loss. And I said, no. Do you know the appealist decision? I stand on my research, said, look, I'll help you out. I happen to have it all organised here, all the links to the major firms. So I sent him that, and he came back and said, well, thank you, I've considered it very thoroughly, but I'm afraid it doesn't make any difference. We still want to exclude consequential loss. So now I was really lost, and I thought I've really got to work out what's going on with this. I thought I'd better look into it more deeply, and I thought the way to do that would be to present on it here to the State Legal Conference, which was a good idea 3, 4, 5 months ago when you pick your topics. But as the conference approached, I felt myself nervously carrying around cases and articles everywhere I went, and becoming more upset and more confused as I went. And it was, I'd read them on the train, and I'd worry about it in the coffee shop, and it was really worrying me before dawn one early morning when I was standing naked on the steps of the Opera House for Spencer Tunic's photo shoot. And I had nothing to read, I had nothing on me at all. And I was really quite troubled, and when they'd done the outside shots with 5,000 of us, they sent 2,500 of us into the inside rooms with more photos, and then 2,500 were dismissed, and so we left. And of course, when you've got 2,500 people trying to leave the Opera House car park all at once at 8 o'clock on a Monday morning, it doesn't work, and the queue was 2-3 hours long. So I went to the place where I knew there would be no queue first thing on a Monday morning, to the Law Society Library. And I picked out my favourite textbook from high school was Carter and Harlan, from university, 4th edition it was then, 5th edition now. And I got back to basics, and I took this textbook and took it back with me back to the Opera House. And unfortunately, just when I'd arrived back, they released the second wave of 2,500 people. And so I stood in the line at the car park at the Opera House reading Carter and Harlan, and that's how we've come to what we've got today. So we'll take it back to basics, and to make it easy, we'll imagine we're at the Opera House. You can imagine me naked, and I'll imagine you know nothing about contract law. The structure is, look, I'm going to run through these headings. You've all seen the paper. I haven't really, I've set out sort of slabs of quotes from cases and textbooks and so forth, but I haven't really joined all the dots through it, so that's the plan today. So starting with the basic, which is damages. And look, I needed to do this to really get to the understanding of the consequential loss issue. Damages as a general proposition, you've got to put the person back in the position they would have been in if the contract had been performed. So it's an expectation loss. It's different to tort, where you sort of put someone back how they were before you slammed into them with your car, but it's more about the expectation, what you have promised to the person and what they missed out because you haven't come through with your promise. There's also, part of this can be a reliance loss as well, where they say, well, I was expecting you to follow through on this, and so I've gone and ordered all this extra product and set up these booked flights, done things, so I'm out of pocket there. But it's usually the expectation loss itself will usually cover it, so you don't hear an awful lot about these reliance losses. And of course, once you get further and further out, perhaps I should, so there's a breach, yeah? There's a breach for acute breach. Now the damages under this concept of expectation loss and reliance can go out an awful long way, and so it creates a desire immediately for remoteness. There's got to be some limit to this, and this is where it all starts getting very sort of vague, I suppose. It must not be too remote. And we're told that the test of remoteness is like tort, but more narrow in contract, it's tighter. And I guess you're asked to rely on your gut a little bit, but we're told the most celebrated case is this old case of Hadley and Baxendale. And the famous quote in it, which I just couldn't understand it at the time, so here we go. They say that the proper rule in a case such as the present is this: where the two parties have made a contract, one of which of them is broken, the damages which the other party ought to receive in respect of the breach, okay, here we go, should be such as may fairly and reasonably be considered either arising naturally. So that's the key thing, first thing, arising naturally, i.e., according to the usual course of things, because arising naturally is not a self-evident, easy to understand concept. So, according to the usual course of things, from such breach of the contractor itself, or, and this is the second limb, such as may reasonably be supposed to have been in the contemplation of both parties at the time they made the contract as the probable result of the breach of it. So as I've sort of marked there as we've gone through, there's the first limb and the second limb. And it's not so much an or in between the first limb and the second limb. I think that's what really threw me, is that it's more of an and or perhaps an and or. And it reminded me of a letter I wrote in a litigation matter, and we were debating whether to use and or, and it became known as the and or letter, which I just thought was fantastic. So Hadley and Baxendale, the first limb is sort of known as general damages, and the second limb is special damages. And the first limb, so is this, is the stuff, I'm trying to draw it graphically. So you breach, the first limb is the stuff that arises naturally in the course of things. It's close, it's stuff that's obvious. Of course, natural is a bit of a vexed term. It's only natural that I should want to be there with you. It's only natural that you should feel the same way too. I mean, it's a way of imposing our view of the world on someone else. And they've tried to formulate it in other ways, like serious possibility, grave risk, on the cards was an interesting one that's come up. Not unlikely, liable result, serious possibility, real danger. And Carter tells us the balance of Australian authority would be the double negative of not unlikely. Strangely, I actually find feeling that there's some safety in the double negative, I think, in that concept. The second limb in Hadley and Baxendale is the wider stuff, which is reasonably in the contemplation of both parties. So the first limb is the stuff that's obvious regardless of what each party knows of each other. And the second limb is the stuff that you're liable for these damages because of your state of knowledge of the other side. And this is quite nice conceptually, I think, because it comes down to contracting. It's a way of saying, well, I knew that when I was selling you this machine that you were going to put it to these particular uses and so forth. And it really sort of impliedly becomes part of the contract. I'm sort of underwriting, those uses and the risks associated with them. And so if it doesn't come off and you suffer losses as a result of your ability to do that, I've accepted those liabilities. So at least it's got a sort of contractual, conceptual sort of concept to it. So there's the first limb, there's the second limb, these are the things you're liable for breach. Victoria Park case tells us the first limb is imputed and the second limb is actual, but it's not actually actual, it's more sort of imputedly actual or supposedly actual, because it doesn't depend on your actual state of knowledge, but more your state of knowledge that you should have given the circumstances and given what you do know, this state of knowledge can be concluded. So we know then that anyone who supplies anything doesn't want to be liable for it. So you get your exclusion clause. You get your limitations of liability and exclusion. I should say that I don't know, conceptually, I guess, in my mind at least, because we're dealing with a rule of remoteness, the potential actual damage could be wider than what these two things are. The first limb says you're liable for this lot. The second limb says you're liable for this lot. There may be some more out there, and I sort of got carried away, drafting some nice. That one looks a bit like a ghost doing a staying alive, and I thought this one looks like a duck, and this one has a little duck looking in on it. I guess, I don't know, conceptually I suppose the actual damage, I wonder if the actual damage could be even less than what comes across from the concept of the second limb. I don't know, because these are strange concepts that overlay each other and you're supposed to make sense of them. So the exclusion clause, this is the classic, the beautiful one you want to rely on as your limitation of liability. So just cut it off with something that's concrete. You can say there's $10 million or whatever, and if you're the supplier, the smaller the limitation of liability, the better. You want to get it down there. And your ideal is if you can say our liability is limited to the price that you pay us, and so it's a zero-sum game, you're set. Now this is great, so excellent limitation of liability makes sense. The problem becomes in when you want a limitation of liability on a concept like consequential loss. So you now got to construct the idea of consequential loss. And there are two schools of thought in this. And you see, I'm going for what Carter says here, they're both wrong schools of thought, and the reason they both must be wrong is because they both try to derive and start from the concept of natural meaning. So they both say this is the natural order of things, the natural interpretation of consequential loss. One goes this way, one goes this way. So it leaves us a little lost. In talking about this, Carter he cited the case of Holt and Collier, and he cited the Justice Fry said, it's important to and I thought this sounded sensible, it's important to the public that the meaning of the word beer house should be ascertained once and for all, because then persons who have to draw instruments relating to businesses of this sort will know on what principles to proceed, and counsel are asked to advise whether there is not a case or not to proceed upon law will know how to advise. And I thought that, yes, that's right, we do. We need to know what a beer house is, we need to know what consequential loss is. These are the great questions of our time. But Carter was very critical of this statement and called it non sequitur and said he said the statement illustrates a belief that words have absolute and constant reference. And he points out that lawyers love labels, and we do. If you can slap a label on it and say that's a lease, that's a license, this person's an agent, it's a very efficient way to do things, and it helps speed the communication with the other side, with your client, all that sort of thing. But as you appreciate with a lease and a license, sometimes it doesn't matter what label you slap on it, it's more what the actual document does determines whether or not it's a lease or a license, or a person's an agent. So sometimes the words are not definitive. And Carter says if it's an exclusion of liability for consequential loss that's its issue, the use of the word consequential is the important thing, and the consequential loss is an important concept, but when we use this clause, we don't explain the content and scope of this underlying concept. We act like we know what it means, but we don't. So these two schools of thought, as I say, both rely on natural meaning. And Darlington Future's case says interpreting exclusion clause, which sounds sensible, is to be determined by constructing the clause according to its natural and ordinary meaning, read in the light of the contract as a whole, giving due weight to the context, and if in doubt, contra preferendum. So it sounds very sensible. You've got to start with natural meaning. Now, what Carter calls the Crodas view, which is sort of relies on the Hadley and Blacksnell framework, and it was attractive because at least we knew what we were doing. He calls it the Crodas view because of a particular sort of famous case that set this out. And what this idea of consequential loss says that it works, it's neat. The first limb is the stuff that arises naturally, is the direct losses or the ordinary losses, and the second limb, the stuff that arises because of the knowledge of both parties, and because I've known enough about your operations that I'm going to effectively accept liability for the potential damages that can be caused by a breach. That second limb is the consequential loss. So that's not bad. At least we had a framework we could use. The McGregor view, and so that's what's existed in England for a long time, and that's what the state of play was here until the Peerless case. Yeah. So the McGregor view is really what comes out of the Peerless case. He calls it the McGregor view because it comes from the McGregor on damages. Yeah, very famous. Costs about $1,000. I realised when I borrowed it from the Law Society Library and I'm waiting in the car park thinking, I've got like $2,000 worth of books on me, this is crazy. So the McGregor view is about the case Peerless. Now, Peerless case concerns an animal rendering factory. Do you know what an animal rendering factory is? I mean, it's disgusting. It's absolutely. So I took an immediate dislike for this case because it's about an animal rendering factory, and I looked one up on the internet, and I encourage you to do the same thing because the militant vegetarian in me wanted to show you some photos of this stuff. But it's basically a big mashing up operation where they get all the bits and pieces of all the horrible dead animals and mash them all up and turn them into pies and pasties, I think, or possibly pet food. But anyway, so this disgusting case, these people, Peerless Animal Squashing Incorporated, wanted to buy something to ease off the stench from their operations, and so they ordered from Environmental Systems some device to make things not smell so bad. This is what Carter very kindly called an oddly worded provision that their case ended up sort of turning on for the consequential loss point. So there's a liquidated damages and a curious use of and/or consequential loss there. But so the clause starts as a matter of policy. Who cares? Honestly, who cares what your policy is? It was my response to that, and I dislike this case even more as the clause unfolded. So, as a matter of policy, Environmental Systems does not accept liquidated damages or consequential loss. Again, I'd rather, it's not a policy statement, it's a contract, so it needs to be framed a little more, the parties agree to such and such. And then they go on, the second sentence says, Environmental Systems is motivated to achieving agreed milestones through respect for the client's needs and obvious financial advantage gained through completion of projects in the shortest possible period. Who cares? I mean, again, it's not really a term of a contract, but out of this we were able to discern that they were trying to exclude liability for consequential loss, and that's the way that's the way it was interpreted. Now, I should say, I've been doing a lot of work, and lawyers and firms sometimes come up to in-house lawyers and say, well, what is it you do? What do you do every day? And I think the answer I've often given, I think it's true, you help people who can't read or write, basically. You read and write for engineers. And this is a good example of where the marketing department, I think, have done drafting rather than the legal department. So this relies on the idea that comes out of McGregor. And McGregor doesn't like this idea of consequential loss. And he says it's a bit silly to put the second limb in place by, if you're purchasing something off someone and you give them all this information, so I'm going to use it for so forth, and you know they know these things, and now you're really expanding and creating your second limb. He says it's a bit silly to have that communication and then say, okay, and then we'll agree to exclude liability for consequential losses. So you sort of build it up and take it away again. McGregor doesn't like that conceptually. He says it's illogical. I don't think that's right, because I think parties talk about everything, talk about all sorts of... Just because you talk about a risk or a possibility doesn't mean you're asking the other party to assume responsibility or liability for it. So I'm a bit partial to Carter, and I accept his criticism of the big thinking there that McGregor's got. So what they concluded in Peerless, they said, so with this clause, it's more likely, rather than using the old English law, the having Baxendale stuff that's been around for hundreds of years, but it's always been a bit, never expressly applied, it's always been a bit unsure in Australia, but they've taken the conclusion that says it's more likely that the parties intended the meaning consequential loss to have its ordinary and natural meaning. So again, now we're back to natural meaning. And it says that consequential loss should be restored to the natural meaning which commercial and legal usage in exclusion clauses has long since robbed it. And Carter says it's a bit funny to find that natural meaning in successive editions of McGregor on damages, but there you go. That's what they've done. And the natural meaning that they give to this, so they say, in their view, an ordinary reasonable business person would naturally conceive of consequential loss as everything beyond the normal measure of damages, such as profits lost or expenses incurred through the breach. Now, so there's a couple of important points about ordinary reasonable business persons. I mean, look, in the in-house sector, there are limited numbers of these people, and to the extent you have some interaction with the T's and C's, it's, here, have some T's and C's in the abstract. I won't tell you what we're buying or what we're doing. We can sign off on these tomorrow. The actual idea of a real fluid communication going on here that gets to this level of understanding is idealistic. But then again, we have to work with under that assumption, otherwise all is lost, I guess. So they talk about what the ordinary business person would think of, and they say the first point is the first point is the normal measure of damages, and consequential is everything that goes beyond that normal measure of damages. So now we've sort of got a new inner circle here. You've got the original first limb of everything that arises naturally, and now we've got this idea of normal measures of damage, and it sort of displaces the beginning and end of consequential loss. And the important thing to remember is the ultimate loss is out here somewhere. So under the previous rule, your consequential loss was this bit. Now under the new rule, your consequential loss is kind of everything between the edge of the new normal measure to the outside of damages, I would say. Well, up to and potentially. It's not exactly clear where it ends. Now, the scary thing about this is we don't know the shape or size of this thing, and I think from a customs perspective, the fear is that the normal measure of damages will be less than what the previous first limb arising naturally are. And this is why customers are now cagey about the idea of consequential loss and excluding consequential loss and just agreeing to that, whereas once it was a bit more of a norm. And the particular reason why they're scared about it being smaller and why it could well be smaller is because in Peerless the court did a weird thing and tacked on some express examples and said everything beyond the normal measure of damages, such as profits lost or expenses incurred through the breach. They named a couple of heads of damages and chucked them out in the consequential loss territory. Whereas previously it was more dictated by concept, and no one dictated this particular type of loss as consequential for all time. And as I'll come back later, you'll see loss of profit is a good example of something that's found consequential or non-consequential depending on the circumstances. So now we have this new regime thanks to Peerless, and I mean I think it was a stupid case. It would, meat rendering factory or whatever, it'll be overturned. But unfortunately, it's now being applied in the New South Wales Court of Appeal in August 2009, Alliance versus Waterbrook. And so as the journals sort of say that you know, the word consequent, all damages, if you start looking at consequence, all consequential, all damages are really caused by or consequent on something, on some breach or default. And now we've got this new regime, it creates a bit of an open-ended inquiry as to where the consequential loss begins and ends. The Hadley and Blacksondale, it conceptually was weak as a thing to use for consequential loss because it was more about the state of knowledge of the parties rather than whether something was as a consequence or caused by something, but at least it was a rule we understood. So you felt a lament, or I did, I guess, for the certainty of what we had once before. But then, when you look at some of the things that have been decided not to be consequential loss, increased production cost, loss of profits, so these are things that are not consequential loss under the old regime. Wasted overheads, loss of profits again, loss of sales, loss of opportunity, increased project costs, loss of revenue. So these are all the sorts of things that I think, well, look, I think there's a lot of business people and operations managers and engineers and people who do contracts, contract managers, who have this concept of consequential loss. And I think they would think all these sort of things, like loss of profit, loss of opportunity, loss of revenue, are all in that sort of outer band that you would try to exclude. And they would think that all these things fall within consequential loss. But they don't, and that's, no, they don't necessarily. And that's been reflected in the previous drafting practice. We almost make consequential loss a defined term by saying, you know, we exclude all liability for consequential loss, brackets, including but not limited to loss of profits, loss of revenue, loss of opportunity losses. So you chuck all that stuff into the definition of consequential loss. But the point is that the certainty we thought we had under the law of what consequential loss is wasn't all that certain in any case. And the certainty we have now, well, it's been uncertain too because even the English line of authority in Caledonia, North Sea and British Telecommunications, Lord Hoffman reserved the question about the construction of indirect or consequential losses, and it hasn't been considered in the High Court either here, so we don't really know what's going to happen. So the moral of the story is the drafting, you can't rely on the term consequential loss. It doesn't really have a settled meaning at law. You know, and as I say, that's been implied in the past drafting practices where you effectively define up consequential loss to include everything you're worried about. So when you're drafting, what do? Well, when they're drafting for the supplier, now here's where I stared down a lot of sort of quiet agony, because I'm putting precedents on this website, Smokeball, for you'll all rush out and buy as soon as we're finished, I'm sure. And you know, I'm drafting for the supplier, and here I've just, you know, I'm persuaded myself that the word consequential loss should never be used. But what do when I'm drafting a precedent for a supplier? I guess you take the most conservative default position and say, well, if you can get away with it, great, but don't rely on it. And I say if you can get away with it, great, because, well, I mean, you want to exclude everything you can, really. You want to have a limitation of liability. If you can exclude everything beyond the normal measure, whether it be there, or there, or there, wherever it is, that's fine. So I think the point is to, it's a dirty way to do it. I mean, if you can get away with it, great, but don't expect that to be the norm, and don't die in a ditch of that. And maybe watch out if you ask for it, because you're asking for something that's, you know, it's a bit uncertain, and it's very possible that the other side will come back and ask for the same thing back. And then you're stuck saying, well, actually, it was good enough for us, but for you, you know. So, you know, this is an extract of one of my precedents where I excluded liability for consequential loss here. I've said it's included but not limited to, blah, blah, blah. And I've framed it like that because it's an easy snip out. You can snip out the consequential loss term without causing too much you know, fear or worry for anyone, I suppose. But of course, I think again, it emphasises the importance of limitation of liability. That's really what you want to be relying on, is your dollar figure. When you're drafting for the customer, well, this is much more complicated, and the complication is people catching up with the law, I think. Obviously, you should avoid references to, well, obviously you don't want your supplier to exclude any liability, but if they ask to exclude liability for consequential loss, you give them something like that, which is much the same. Well, you give them what you have to, but that's got all the same stuff in it, but the concept of consequential loss, or the words itself, having been removed. Another way to get around it is to define consequential loss. I mean, this is a bit of a, you know, it's silly, really, but I've got away with this where people say, well, our delegated authorities say that we have to exclude liability for consequential loss. You say, okay, well, let's make it a defined term, and then you can exclude that. So now you've created some certainty of what consequential loss is. It's silly because you could define any defined term to mean anything, but it'll be good enough to get you through. And of course, look, These are fulsome exclusion clauses. I wouldn't say every customer would want to agree to exclude all these headers of liability, but like anything, you've got to look at what's the purpose of the deal, what are you trying to achieve, what's the risk, what's the fair allocation of risks, all those things. Other ways I've seen people talk about getting out of it through carve-outs. You know, you might give them the limitation of liability or the exclusion of consequential loss, but carve out certain types of losses and say, I mean, the first couple of sort of go without saying, personal injury, fraud, they're non-contentious, but carving out liability for intellectual property rights, if they infringe third-party rights, you could say, well, I don't want that to be subject to limitations. You could name specific indemnities to which it doesn't apply to. The second to last one is that, I mean, you could do a whole other presentation on this, and I've seen some, and I'm not exactly sure what the state of play is, but you know, it's a good concept saying, well, you know, yeah, we'll have a limitation of liability of $1 million, but you've got $20 million public liability insurance. So if your insurance is going to recognise the liability, I'd like you to use that, and we would like the benefit of the full 20 mil. So in respect of insured liabilities, you know, your liability should be capped at the 20 mil. The risk in that is the circularity that insurance won't kick in until the liability is crystallised, and so it's not an insured liability until that happens, and so you get the circularity that the liability hasn't crystallised, the insurance hasn't kicked in, so you're left with nothing. I've seen people do that by way of a waiver, saying, you know, you'll allow the liability to crystallise and then waive beyond a certain point, but as I say, look, that's a whole other session. So, but that's something people are playing around with a bit. Liability for losses recoverable for third parties. I mean, that's a similar sort of concept as the insurance one. So those are some of the ways people are carving out. But again, the moral of the story, I think, is if you're a customer, you don't want to accept liability you don't want to accept an exclusion for consequential loss. If you're a supplier, get away with it, great. But you know, look, bear in mind, it's not a term of art. A lot of people are treating it as a term of art, and it's not. And so you've got to have the uncertainty that goes with that. My postscript, I wrote in case. Well, I put this in when I was feeling particularly nervous about what I was going to talk about. I thought I've got to chuck in some value at the end here. Look, it's relevant. Supply agreements, customers and suppliers supplying to each other, exclusivity as well as the exclusion clauses is the thing that I see come up again and again after the event. And the problem arises when one party thinks they've got an exclusive supply agreement and one party thinks they don't. And it's just amazing how that perception can come up. So, you know, usually if it's exclusive, we say it's exclusive. But usually if it's not exclusive, the risk is some people don't say anything, they just leave it unsaid. So my practice is now, if it's exclusive, say it's exclusive. If it's not exclusive, say it's not exclusive. And make it very clear, they're not the exclusive provider. Any forecasts are you know, non-binding. You may engage any other party. And then there's another one here saying, to the extent where you may even use your own resources, you may, you know, all these things that probably go without saying, but can be cause for disputes. So, you know, there's my little add-on. All this stuff's in the notes. Thank you very much for listening.
We have about 10 minutes for questions. Are there any questions of any of the panelists? Yes.
I just have a question of Eric. Law Society lease form. Do you recommend using it, and what sort of problems do you have?
Law Society lease is still around. I don't have anything critical to say about it. All I'll say about it is that it's a plain English lease, and I've found appropriate uses for it myself, particularly when I'm acting for a lessor, for a self-represented lessee. It's a lot easier for someone to read through. Depending on the property, it may not have enough detail in it, but as a lease, it's very fairly balanced and it's good to use. Thanks.
Yes.
For Eric as well. Eric, you mentioned about independent certificates of independent advice for circumstances where directors are signing guarantees for companies. In particular, consequential matter that arose, I've never been asked, nor have I asked for that, and I found it intriguing.
Certificates of independent advice, as far as I know, not the norm in New South Wales. I understand they're the norm for leasing in other jurisdictions, particularly Queensland. I personally, in New South Wales, I try away from giving certificates of independent advice in a leasing context.
Anthony, you talked about defining consequential loss. Can you define it as the first limb, basically?
Yeah, I've seen a paper that does that actually. You know, looking at the things people have done before me, and there was a guy who drafted. I'd never really seen a clause like it, but yeah, he drafted. I think it was a Baker McKenzie suggested clause and said, "Wow, it was presenting as an option. You could define it as the first limb under Hadley and Blackstone, blah blah blah." So make your.
Well, I was thinking more that you say consequential loss is any loss which is other than that that's using the words out of the first limb.
Yeah.
Naturally occurring, whatever it is, but do those naturally occurring words, have they changed?
So yeah, I suppose the correct. Well, there are different frames of words. You know, the next case is uses different words, but they still use the words naturally and so forth. So, I mean, this clause was framing it as if saying, you know, citing the extract out of the case and saying such and such a case. So whether, I mean, it's I don't know. I think it's a really conceptually interesting idea. It's almost sort of trying to outflank the court and saying, well, you know, it's like codifying case law almost, isn't it? You're sort of saying, well, we're gonna start writing these slabs down and attribute set meanings to them as we put in our contracts. I think that could result in some really interesting decisions from the court as saying, well, we know we said that before, but now that those words mean something different. I don't know. I wouldn't. I mean, I just think it looks it's bad enough showing or citing a case to your client, let alone writing cases in their contracts. I would never do it, but I've seen it raised as a possibility.
I've seen something very similar like that. This use the actual words.
Yeah. I don't know. I don't know of any cases where that's been analysed, but I don't know. It's an interesting idea.